Breaking news, fresh off the presses. Let's go. If you can, man, hit that like button. We just gonna get straight into it. Man, this is a terrible day for Durk. So anything granted is good for Durk. Anything denied is bad for Durk. Got it? Granted, good. Denied, bad. So this basically happened in Chambers. Bank's motion in limine to exclude government's proposed FRA 404B evidence. And then it says before the court is the motion in limine to exclude the government's proposed FRA 404B evidence. And it goes down and says the court held hearings on November 18, 2025, January 7, 2026, but deferred ruling on the motion throughout this period until the hearing on this motion on February 9, 2026. The parties filed a flurry of briefing on the issue, which means this basically turns into a tennis match as how this is going to read. The government filed a supplemental memorandum in opposition to the motion, the supplemental opposition on January 2nd, 2026. That's the feds. Then Banks and defendant DeAndre Wilson filed a supplemental brief in support of the motion on January 23rd. That's basically them hitting it back. The government filed a response to defendant Banks' supplemental brief. The response on January 30, 2026, defendant Banks and Wilson filed a joint reply. The joint reply on February 3rd, 2026. Finally, the government filed a supplemental memorandum in the opposition to the motion, the supplemental response on February 6, 2026. As an internal matter, the government initially indicated that it intended to introduce evidence surrounding an incident that occurred in 2022 in Chicago. That was the previous video. Y'all should already know that one, but if you don't, then you can check it out on the page. It's perfectly fine. At the hearing, the government withdrew the evidence for consideration. The court also expressed its tentative view based on the briefing that it was inadmissible under either Rules 404B or 403. The motion is therefore denied as moot. As to the requested evidence, references that the incident will not be admissible without obtaining the express permission of the court. Now, even though I'm pretty much going to give y'all some bad news today, that's actually some good news. That's a W for the defense. So that shooting, the quote unquote killing, the quote unquote blasting and all that stuff, they said, nah, we're not bringing that in. So the quote unquote get back for my brother, that shit, out. Let's continue on. Birdman hands, bang! Before we move on, here's something you can do and get paid for. This is called free cash. Free cash is number 2 on the Apple Store and pays you to play games. You can make $500 plus a month by playing games for free. Use my QR code or the link in the description to get $5 when you download and sign up for free. Download and get paid on your phone and start playing. So the dang screen went back up, but it doesn't matter. So it goes on to say Rule 404B notice, right? The government has given notice of potential Rule 404B evidence in several instances. The initial, notice is dated September 1st, 2025. Then it goes on to say notice dated November 17, 2025. Finally, the government sent a third supplemental notice dated January 16, 2026. So it says Banks first argues that these notices provided by the government were not specific enough under the 2002 amendment to Rule 404B. But as Banks himself acknowledges, the heightened requirements of this amendment are meant to prevent trial by ambush to ensure that courts can evaluate admissibility based on the government's actual theory rather than post hoc rationalization. As to the first concern, Banks cannot claim trial by ambush given that he is litigating this motion well in advance of trial. As to the second concern, again, the fact that the government provided advance notice of much of its 404B evidence mitigates the effects of any post hoc rationalization, since the government cannot be said to be sandbagging the defense by switching its relevance theories too close to trial. However, should the government seek to offer additional evidence under Rule 404B closer to trial, as the January notice seems to indicate, the government should take care of it strictly complies. It strictly complies with the notice requirement to give defendants fair notice of the evidence, particularly in light of these rulings. 404B, evidence not subject to Rule 404B. Both parties seem to agree that certain items of evidence are not other acts. So basically, before I even start, I don't want to click off the screen and let y'all see my face because it doesn't really matter. Basically, that's a win for Durk because Durk was initially saying, bro, y'all need to not ambush me. The court's saying, no, fool. You already know this. It's like a sneak attack. A sneak attack you're not supposed to see. Banks, aka Durk, is saying, yeah, y'all finna sneak attack me, but the judge is saying it can't be a sneak attack if you're already calling it out. But also, it's a W because they're saying y'all need to hurry up and give them any more evidence that y'all plan on using. So hurry up with that shit. You better get done with that. So both parties seem to agree that certain items of evidence are not other acts of defendant Banks because they are not attributed to Banks and thus do not fall within the ambit of Rule 404B. It's really small on mine when I'm reading this, so I know some of y'all like, bro, you keep on messing up. It's because it's small. So I could increase it like this, but I don't think it'll look good on the camera, but let's see. Anyways, fall within the ambit of Rule 404B. Specifically, the Ninth Circuit has held that admissibility under Rule 404B requires the showing that the evidence must be sufficient to support a finding that the defendant committed the other act. Accordingly, because several pieces of evidence are not attributable to Banks, challenges to admissibility would seem to fall solely under Rule 404B. These items of evidence are surveillance footage and witness testimony related to the murder of DB in Atlanta on November 6, 2022. So if you're in court, you're going to see some statements made by some people and you're going to fall out your damn chair. Public pressure from fans of Banks and OTF demanding that Banks exact revenge for DB's murder. September notice at 14. And I think that's going to eventually become something for people. Like, y'all can't be doing that shit. But I don't know because it's free speech, but it is what it is. Another item of evidence that seems to fall outside of Rule 404B are the comments made by Banks on a podcast. While it is undisputed that Banks was the one who made the comments, the quote would seem to fall outside of Rule 404B because it does not appear to be propensity evidence. The evidence consists of the following exchange. Banks was asked on a podcast if he was triggered by the Slide for Vaughn comments, and Banks responded, "For some reason, I just don't see them comments no more. For some odd reason. Might be the water. We hear them." It is unclear why the government indicated this evidence was subject to the structures of Rule 404B in the September notice when the government now seems to concede that it falls outside of Rule 404B. Banks suggests that the government benefits by casting this evidence as inextricably intertwined with its prosecution of the case in order to argument itself to present, inextricably intertwined with its prosecution of the case in order to avoid the safeguards of even Rule 403. But the government itself presents no argument or case law that this evidence should be exempt from 403 because it is intertwined with its presentation of the case. Accordingly, the court will consider the evidence under Rule 403 standard. So they ain't rule on it. And stupid ass Slide for Vaughn comments that he decided he wanted to give to freaking academics. Y'all let me know your thoughts so far on this because so far it's all right, but it's about to get a little bit grim. If y'all can, man, if you have not, I think we deserve the like so far, or maybe just wait a little bit. But if you can't hit that like button, force us into the algorithm. Let's get it going. Roll it. I don't know if we should skip through this. As to surveillance footage and witness testimony related to the murder of DB, the government argues that it is relevant to show the motive for the crimes in this case. The second superseding indictment, SS1, alleges that DB, aka King Von, who the parties agree was a close friend of Banks, was shot and killed following a physical altercation, whatever the hell, and that basically was the reason for all of this shit, the bounties included. In response, Banks argued there is no probative value in delving into the facts. And hold on real quick. I want to see if I can make this full screen. All right, cool. Sorry about that, y'all. Because that shit at the top was killing me. Anyways, in response, there are no probative values because Banks was not aware of the details of the incident. There is no need to present evidence of those details. Moreover, in the reply, Banks argues that the murder of DB was attributed to Timothy Leaks. So they're saying that Lil Tim did kill him instead of the police. And that because Banks did not target Leaks, and this is what I was saying, Leaks killing a DB does not bear on Banks' purported motive in this case, where Leaks is not the victim. This evidence seems plainly relevant to the prosecution of the case. Indeed, The fact that TB and DB were involved in an altercation prior to his murder is the foundation for the government's theory of why Banks was motivated to put a bounty on TB. And Banks has only argued that this evidence will result in a mini trial to establish the facts that, given what the government really seeks to admit is a historical fact, that DB and TB were involved in altercation, but the government indicates that this evidence will be coextensive with the presentation of its case, and in particular, blank. Given the significant probative value of the evidence of this altercation, any time spent establishing the facts of what occurred on the evening of DB's death is not needlessly commutative or a waste of time under Rule 403, particularly considering the government's representation that blank for these events, according to the motion, is denied. Damn, so it's coming in. As to the surveillance footage and the witness testimony. So that shit is coming in. Public comments from fans. Next, the government seeks to admit evidence of fan comments that appear on Banks' X account and were authored by anonymous users, among other potential similar social media comments. We ain't finna do all that. It says Banks makes several objections, but the court agrees with the government that Banks' own statements indicate he was aware of these type of social media comments. See, and that's the shit right there. Like, that's where Lil Durk, like, screwed himself over. You're never supposed to let him know. But anyways, in particular, Banks was asked on a podcast if he was triggered by the Slide for Vine comments. And Banks responded, for some reason, I just don't see the comments no more. For some odd reason. Might be the water. We hear them. In response, Banks argues again that he is not charged with seeking violence against DB's killer leaks. And thus, these comments urging Banks to seek revenge for DB's killing are not relevant to motive, but the court has already explained why the murder of DB is relevant to the motive for targeting TB. Accordingly, these comments may be admitted to show the effect that they had on Banks, and the motion is denied. So those are coming in. That ruling right there is going to stop people from going on Vlad, going on No Jumper, going on academic shit. Everybody who asks these police-ass questions that everybody has been saying, bruh, talk about the music, talk about the music, talk about the music. Now, some would claim, and I would understand if you say, well, he just didn't have to answer it. He could have just said, I don't know what you're talking about. That's true. But academics is smart enough to know, bruh, asking this damn question in particular, you're seeking a response. Now, if I'm academics, I'm finna play deaf, dumb, and blind and be like, bruh, he didn't have to answer that shit. These are comments that y'all put up there. Don't blame me. The fans drive my questions. And if that's the case and he wants to argue that, then you could not argue against him, because one could argue the reason for a lot of these interviews are to answer fan questions that people basically have. But I'm telling you this, from now on, all you rappers that go on these major platforms and do interviews about criminal street shit, it's all being recorded. The state is following, the feds are following. Let's continue on, because academics has to basically explain this shit away. He can't run from that one. Let's go. Podcast comments. As discussed above, these comments are relevant to establish Banks was aware of the public pressure to avenge DB's murder, and such public pressure is relevant to the government's theory of motive for these crimes charged. Basically, nigga, you crashed out because of comments. You didn't crash out for nothing else but that. Which, if that's the case, he's found guilty, and there's some crazy evidence that says he's guilty, Lil Durk and his fans, y'all the worst. I'm not a fan of nobody I can support, but I'll never be a fan. Fan is short for fanatic, and I'm sorry. These are human beings at the end of the day. Banks' next argument is the admission of these comments would necessitate further witnesses to explain the meaning of these comments. Banks suggests that the statements were mere hyperbole or an example of a celebrity playing into online disclosure as a method of marketing. Banks argues this testimony would unduly delay the trial. Banks further argues that he will invoke the rule of completeness to play the 3-hour-long podcast interview to avoid any misunderstanding or distortion by only presenting this one snippet. Yeah, but playing the whole entire thing, yeah, no. So they talking about playing academics' whole entire thing. But the argument that presenting a complete witness to contest the meaning of Banks' statement or that invoking the rule of completeness will cause undue delay is unpersuasive. Again, the government seeks to admit this evidence to establish that Banks was aware of the public pressure to exact revenge for DB, and that this pressure contributed to his motive to exact revenge. These comments are thus not merely minimally probative, but again, are important to the government's presentation of its case that additionally witnesses or additional portions of the podcast should ultimately be admitted at Banks' request, therefore does not establish undue delay. So, yeah. Academics, Fed evidence. That's you, buddy. Let's go. The government seeks to admit several pieces of evidence regarding the structure of OTF. So Instagram messages showing Banks telling another rival, "I got them hunting you." That was discussed via text message to other alleged OTF members September. Notice. Text thread showing Banks telling other OTF members that he was going to pipe it up in response to messages about a feud with another rival. And voice memo from OTF member blank discussing OTF structure. The court will address each turn. Message, "I got him hunting you." And then it says this message was allegedly first sent on Instagram from Banks to another rival in April 2023. "I got him hunting you" adds, what the fuck? "I got them hunting you" up ads better have 3 masks on. That's bad. The government acknowledges that the recipient of the message is another rival of Banks and does not argue that the rival was involved in crimes charged here. Wow. Rather, the government asserts that in its opposition that a screenshot of the Instagram message was sent via text message to Wilson. Whoever the hell is responded to his text message warning Banks to protect himself in light of the threat, stating, "If you talk to them, blood on the DM, text them in vanish mode." So whoever is out was like, "Nigga, you telling on yourself, stupid." As to the proposed admitting these texts, the government asserts that the message makes clear that Banks, "I got not another OTF member," has control over OTF associates that were hunting the rival. As such, the message demonstrates Banks' modus operandi of threatening rivals, funding acts of violence against them, and Banks' control over his OTF associates. Yeah, that's pretty fucking bad. Banks responds that there is no evidence that he ever followed through with any punitive threat contained in the message, and thus it is pure propensity evidence meant to prove that Banks is a violent person. Yeah, but let's see what the hell they say. As the government argues, the Ninth Circuit has held that evidence of prior criminal acts may be relevant in conspiracy cases to show the background and development of the conspiracy. Conspiracy meaning you can think about doing it and act like you're going to do it. Like when Trey hopped out of the car and goddamn Menace to Society. Boys in the Hood, he would have went to jail. He knew they was going to go kill people and he had a gun his goddamn self. Yeah, Trey was going to jail if the police ever found out his ass was in that car. Just wanted to put that out there for y'all. And if you argue that, then you're stupid and shut the hell up and get the hell off my page. Accordingly, evidence of prior acts may be admissible to demonstrate the existence of a criminal association and plan. So, that is the case here. As the government argues in its opposition, the relevance of this evidence lies not in the content of the Instagram messages containing the alleged threat to the rival, but rather in the act of Banks sending the screenshot to Wilson, which means go get his ass, man. This evidence thus illustrates the nature of the conspiratorial relationship that demonstrates the existence of a criminal association. Sorry, I didn't see that. The government further argues that the statements made at the November 17, 2025 hearing, it appears that one of Banks' defense theories will be that OTF was only a legitimate association among musical artists rather than a criminal enterprise. Accordingly, the need for the evidence of prior threats against rivals discussed by OTF members is high to show that OTF was not merely a group formed for music purposes. Taken together, the government thus clears the hurdle under Rule 404B. We ain't even finna read the damn rest of it because we just gonna get to it. The last question is whether the probative value of this evidence is outweighed by prejudice or another basis under Rule 403. The court argues that this evidence has a high probative value insofar as Banks intends to argue that OTF was only formed for legitimate purposes. The fact that Banks discussed punitive threats against rivals undercuts this assertion by the defense, while Banks has argued that the evidence also carries an inference of propensity for violence. The probative value outweighs the relative prejudice. In this instance, the motion, therefore, is denied as to evidence, meaning it's coming in. This is why the trial being pushed back is a very bad thing, because if the freaking feds can find crimes of this shit, of certain crimes that happen within that, bruh, it's gonna be a wrap. So far, this looks horrible for Lil Durk. I don't even give a shit what I may have said before. I still believe that he's gonna beat it because you're saying that he said this shit, but still, we didn't see any sliding on that individual. Now, if they compel that person to testify and he comes out and he says, oh, my car was shot up, here's this picture on this date and it's close to that date, then hell nah. Now, me, if I'm the lawyer, I'm pulling up the whole entire text thread of these cats talking shit. Meaning, yeah, we speaking in hyperbole. So it could be like somebody having a rival saying, I'm going to punch you in the face. Oh, you are? You going to punch me in the face? Yeah, well, I'm going to kick you in the ass. Well, you say you're going to kick me in the ass, I'm going to body slam you. You say you're going to body slam me, well, I'm going to bite you. Oh, you going to bite me? I'm going to stab you. Oh, you going to stab me? I'm going to shoot you. Oh, you going to shoot me? I'm going to kill you. That's the only way, in my opinion, that you can argue that. If you agree with that, hit that like button. If you don't, tell me why you don't agree with that part. Type right now. I'm going to keep on reading for you. Let's go. So this is already a longer video than what I wanted to do. So basically, they're just going through and they're looking at a lot of stuff, memos and all this shit. And what you're going to see is denied. Voice memos coming in. The voice memo on here, it says, we can go and basically... He want people to get sliders, stuff like that for sure. And voice memo only refers to someone named Blood. And that's the one who they're basically saying that Lil Durk is Blood. But then it says, Banks responded, there is no evidence that Blood was referenced to Banks. Moreover, Banks contends that the messages surrounding the voice memo reveal that blank were messaging someone named Unk, not Banks. So that's their shit. But once again, they go through and say denied. It's coming in. May 2021 attempted killing of TB. And basically, the government seeks to admit surveillance footage and witness testimony related to the attempted murder of TB on May 2nd, 2021. And the government argues that it is direct evidence of the stalking charge. So this is where they're trying to double down on the stalking charge, why they haven't fully dismissed it. Because if they can prove that these cats shot at Quando Rondo before, yeah, that would be stalking because y'all did it in Georgia and y'all did it in California. So they go on to cite a whole lot of case law, and we just basically want to know, is it going to be denied or not? See, the government contends that that the evidence in 2002 attempted murder will come in through testimony, and whoever the hell is snitching, that's right here, according as in Williams, the testimony regarding uncharged 2021 shooting provides necessary context. The evidence of the 2021 shooting is thus inextricably intertwined. And so, once again, as to the unique prejudice under 403, evidence implicating participation in an uncharged shooting is certainly prejudicial, but given the evidence high probative value to the stalking charge, the relevance is not substantially outweighed by the prejudice. So the motion is thus denied as to evidence of this 2021 shooting. All bad. So then it goes to music admissions, and we just go all the way to the bottom because we can see all of this shit. So y'all want the conclusion? The conclusion is simply this. The motion to deny as to, basically, these are all the L's that Durk just took. Surveillance footage and witness testimony to the November 22 shooting of King Von denied. Motion as to the public comments from fans to show their faith denied. The motion is denied as to the podcast made by Banks. The motion is denied as to the Instagram messages related to text messages and all that stuff. The voice memo, the surveillance, all of this stuff. The motion is denied as to the following lyrics. So they're allowing these lyrics to come in. They be on my page like Slime for Vine. I know they trolling me. Got it back in blood. Y'all just don't know that's how it's supposed to be. God damn it, Durk. Banks. Don't respond to shit with Vine. I'm like, fuck it. You tripping. Go get your gun. They dropping locations. I'm getting it done. Fuck tweeting. We sliding. The feds are coming. But then he says in the beginning, this shit is all cap. This shit is not real. It's all props. So they're going to add that, of course. Banks. Got Diddy with me. Threat. No. Big threat. Block war. I got Diddy with me. He a block boy. Then you got Wilson. Whenever you with hop in the car with gang, then you know it's all pressure. Members pop our switches, and they know they so extra. Knock them off close. OTF, we doing long distance. Sheesh. But let's get the W's out the way before we give y'all the final. The motion is granted. As to music video footage, although screenshots may be permissible, the motion is granted without prejudice. To the extent the government may offer music videos that function as a bounty or reward for the acts charged and for one video depicting Wilson and Banks together. That's it. Okay. The motion is granted as to the following lyrics. So these ones are out. Wilson, we got time to slide. The only thing we ducking is the Jakes. Grab my Glock and there ain't no safety. All my niggas, they fighting cases. Murder ones, they beating the state. Wilson again. This nigga trying to go off. This is telling ass lyrics, ain't it? But thank God they didn't get admitted. I'd have masked up with gorillas, 100 shots up in them sprinters. If he died, that's what he get. 100 shots up in the whip. I take pride in doing hits. Go outside and do a blitz. The homie died because we ain't missed. Thank God that shit come in, cuz. Wilson, we spin his block. We pop that car on his ass. I hate to wait. I never heard of dude. Only time was on the news. God damn. Yeah. Hey, y'all needed this shit out. Wilson. We don't shoot our cars. Following them hop out, we hawk you down, and I'm close range enough to ask that nigga how that chopper sound. God damn. Yeah, they got that thrown out. Banks. Before they spin, tote the tents, dog could go fool his ass. He think he buy some new cars. We hop out, schoon his ass, fool his ass. He ain't paying attention to his car because we got them Uber tags. That's gone too. As to the lyrics, referencing a bounty, the court may permit these lyrics to be admitted if the government can adequately explain their probative value in the context of how they will be presented and admitted at trial. Without understanding the probative value of these lyrics and how the lyrics will become admissible, the court is presently unable to conduct Rule 403 balancing. The court will discuss this topic with the parties at the next hearing. These lyrics are, we ain't trying to make peace with them boys. I pay my rent and my shooters. So we still waiting on that. Then I don't want no niggas out. Shit. I don't think this one's going to be let anyways. I don't want no niggas who you catch. I want the one I paid for. Trolling ass. We shot your homie. Whoo, that's pretty bad. Banks. Popping traffic. We in Cali ride through Beverly Hills with choppers, bounty hunting. Then Banks. For them niggas who carry, I buy them 50K in guns. It is so ordered. So all in all, even though we seem like a pro Durk channel, we just really anti the feds. No hatred towards them. It's not like they didn't just hold me up in a room and threaten me with 20 years for some shit that was a joke. But it is what it is. Depends on how you look at it, right? I say it's bad because the feds got in lyrics. That's always bad. I don't give a shit how you spin it. But you can take this as a short W because they didn't get in all the lyrics and they weren't able to stack multiple shit on top of multiple things. So if I'm Durk, I'm like, all right, it's an L today, but it's not a big ass L. It's like a punch in the face. You got a little blood on your lip, but you ain't bust my nose. You ain't black my eye. I can still see. We can still fight. Those lyrics, depending on the song and how they start and certain shit in the lyrics, bruh, it is what it is. But if I'm Drew Finland, I'm looking at mid certain lyrics too. Certain lyrics that show that Durk don't know half these people that he talking about. He once said he knew somebody who did plumbing and all of this shit. He once said he knew somebody who built houses. There are lyrics that Durk say that it's just like, you clearly don't know none of these people because you could have built Wakanda, homie, and you could have had cyber shooters. You could have shot this person from all the way in Atlanta. So it's definitely a L today, but it's not a big ass L. I don't know, some of y'all are like, no! You're supposed to be paid by Durk. Only admit that Durk won today. He didn't. It's a W if you get all the damn lyrics out of there. But here's the biggest W that he has. The government says, yeah, okay. You want a bounty on King Von. Killer. Right? Because King Von's killer, according to the documents, is Lil Tim. Lil Tim ain't dead. Lil Tim ain't shot at. None of that shit. Lil Tim was shot by the police, and that's it. So I hear everybody. I see what they're all saying. But the government took an L with that one. They think they're winning that one. Because if I'm Drew Finland, I'm saying, well, I don't know if you want to poke the bear. Lil Tim ain't dead. Lil Tim ain't shot at. So F is y'all talking about. If you like what we do here, man, consider hitting that like button like you like some. One of these are for free for the persons that are commenting every video and liking every video and sharing every video. But hey, breaking news. We just dropped it like it's hot, boy. It just came out about an hour ago. It took an hour to read all this and react to it. So that's why you didn't get it faster. But I got it done as quick as I can, man. Other than that, enjoy your night. We got 2 more videos going to drop on the Reloaded page. But click right here to see how Bompton Blood got it bracket on Adam 22. Lordy, lordy, lord. Click right here to find out all about that, or click right here for the playlist, and I will catch y'all in the next one.